we have the living will. And that's the document that says if I'm terminal, end stage, or in a persistent vegetative state, and two doctors have certified that everything's been tried. We've tried all the treatments and nothing's worked. This document would allow me to die naturally with hospice. Why is that important? Well, if you can't express your wishes and you don't have that document, and your family's arguing about what your wishes were, we again then go to court, and then the court decides what happens to you. And unfortunately, I've been on a case like that where two brothers, there was no living will, and two brothers were arguing as to what Dad's wishes were. He had had a severe stroke, and unfortunately the judge had to decide. And the judge doesn't want to be in that position. The court appointed doesn't want to be in that position, and it's just an easy document to have so that you can explain your wishes. That is distinct from the do not resuscitate order. So a do not resuscitate order is a separate document that your doctor signs and the healthcare surrogate can execute that says, if I go into cardiac arrest, you're not going to basically break my sternum and bring me back. Why is that important? If your loved one is in their late 80s, early 90s, and suffering from dementia, Alzheimer's, and is extremely frail, if they resuscitate, you're going to have a broken sternum, infection, poor quality of life. So many people that are terminal want a do not resuscitate order. If you're 50 and healthy, you don't want one. I had a young woman come in and she said, I think I want a do not resuscitate order. And I said, are you sick? And she said, no. And I said, I think you want a living will. So if you have the do not resuscitate order at home, there's a really quirky rule about it. It has to be printed on yellow canary paper, and it has to be taped above the bed of the elder. Everybody puts it on the refrigerator on white paper. It's not valid unless it's on canary yellow paper on top of the bed. And that's when the EMTs are called if you want it to be valid and you want them to see to not resuscitate. HIPAA releases are generally included in the healthcare surrogate, but you can have a separate HIPAA release. So where would that be valid? Let's say you have one child making all the medical decisions. They would be named the healthcare surrogate. But you want all the children to have access to the medical so that they don't feel left out. We would then do a separate HIPAA release for the other children that would not give them the right to make medical, but then they could get information as well. And sometimes that's important because the most stressful time in families is when an elder is getting sick and going through the aging process. When the last elder is sick, either husband and wife, that's when really I see the family kind of disintegrate. So if there's tension between the siblings and there's a lack of trust, you're going to see it play out usually in litigation at the death of the last spouse. If you are able to let as much people have information and feel included, that will help hopefully mitigate some of that distrust. So that's something that many people want, is they want all children to have access to medical. The next document is probably something you've not heard of. It's called a declaration naming pre-need guardian. This is a very important document to me because I do a lot of guardianship litigation. This is a document that says, while I have capacity, if I ever need a guardian or if someone files for guardianship against me, this is who I want to be my guardian. Or in some families, this is who I don't want to ever serve as my guardian. Why is that important? Well, in Florida, nowadays we all live in different places. So the elders rarely live close to their children anymore. So the scenario I usually see is one child quits their job and takes care of mom and dad, and the other children are scattered across the country. Let's say that the child in Wisconsin's the eldest, and they fly in to visit mom and to go to Disney. So they drop by a few hours to visit mom. At that time, they get it in their head, I think she's probably taking money and doing something wrong. because she's with mom all the time. So that child goes to an attorney and files for guardianship against mom. That happens frequently, and if you have the declaration naming prenatal guardian, that will help stop the litigation, because the standard is very high that the judge cannot appoint that person. So the judge has a duty to appoint that person unless it's proven by evidence that that person's appointment is not in the best interest of the elder. So you would have to show that that person had a felony, they wouldn't be qualified if they did, or that they aren't good with money, or that they are only interested in money. So there would be a hearing about that.